Good morning, everyone. I'm Ariella Wagner, the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, suppliers with their construction notice to owner needs. Today, we have a really fantastic webinar on notices to owners, liens and bond claim refreshers with pro tips. So without further ado, I shall introduce the fabulous attorney, Alex Barthet.
Thank you, Ariella. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today we're going to talk about notice to owners, liens, and bond claims at a 101 level. But for those of you that know the rules, we'll give you some pro tips. And importantly, if you have questions, we'll make sure to answer them at the end. So what are we going to cover today? We're going to start with why notice to owners, liens, and bonds even exist. Why are they important? Then we'll break down each one into each section. We'll talk about notice to owners, claims of lien, and payment bond claims. And as I said, at the end, we'll answer any questions that you have. The way you ask questions is use the GoToWebinar question box. Go ahead and type your question in during the presentation. We'll answer them all at the end. Please do not include the names of any people or companies in your question. So let's go ahead and get started. Why notices, liens, and bonds? Why are we even talking about it? Why is it important? Well, understand that that the law in Florida and in many states allows those that improve property to have a security interest in that property. And the exchange for getting the right to that security interest is to follow certain rules. So the rules that exist typically require you as a lienor to jump through some hoops and provide certain notices within certain amounts of time. And we're going to talk about what those timeframes are. So the reason that this is important is that these documents put everyone else in the chain of construction on notice of your rights. And generally speaking, it's not always the case, and there are many exceptions to the rules that we're going to talk about today. But the failure to timely serve these notices or to serve the wrong notice will invalidate your right to have a security interest in the property. And when I say a security interest, what I mean is if you work on a project and you have lien rights and you exercise those lien rights, if there's any equity in the property, then you have the right to sell the property on the courthouse steps, and any equity that exists in that property will be liquidated in the form of a sale, and you will be paid. It doesn't always guarantee that you're paid in full. There may be no equity in the property that you lien, but it gives you a very strong right to take the property away from its owner. The other reason these notices are important is that it lets everyone know that you're serious about getting paid. You know the rules, you know how it works, and you're going to follow the rules to make sure that you get paid to secure the longevity of your company. As I said, it's required to secure your rights. If you have an obligation to send any of these notices and you don't, you will not have a right to the property or the bond claim. And interestingly, and probably, barring the actual ultimate sale of the property at a foreclosure sale, these notices have an immediate effect on the project, because those that understand the rules know that when they get a notice from you, that they need to get a release from you every time they pay the contractor. So your notice acts as a marker for them to say, oh, I'm going to pay the contractor. Well, I got this notice from this sub or supplier. I'm not paying you, contractor, until I get a release from them. So your notice causes the owner to know that you exist on the property and require that you are paid in order for them to pay the contractor. And that check and balance is critical And I would tell you that, in my opinion, having done this now for 20 years, that the notice, the true value of the notice day to day is more about that check and balance, about getting the owner to know that you're there and therefore require a release from you, or the contractor to require a release from its sub because you sent a notice. That is a much more everyday power of the notice laws than the actual ultimate foreclosure of the property. Not that that's not important, but the way we really see it happen day to day is that. So with that as the background, I want to turn it back over to Ariella, who's going to talk about notice to owners and go through some of the key points for understanding notice to owners. Ariella?
Great, thank you, Alex. So what is a notice to owner? First and foremost, a notice to owner, if you do not have a direct contract, whether it's verbal or written, with the owner of the property, in order, as Alex stated before, in order to secure your lien or bond claim rights, you need to send a notice to owner. The time frame to send a notice to owner is 40 days from the first day you furnished labor and or material to the project. Now, there is an exception to that rule, and that's specially fabricated material. So when you're working on a specific, hypothetically, glass that can only be constructed for a specific building, that would be considered specially fabricated. So the clock starts ticking as soon as you start fabricating. So we're going to get into the difference between private projects and public projects. Who needs to send it on a private project versus who needs to send it on a public project? So what are private projects? Those could be your, obviously, residential properties, commercial properties. Public projects, on the other hand, are owned by the city, the state, the county, and those projects cannot be liened. There's no such thing at all in the state of Florida of liening a public project. Think of it very logically. The purpose of a lien, which Alex is going to go into shortly, the purpose of the lien is to cloud the title of the property where you can foreclose on it, and you can basically, possibly, end up owning a building. Now, we can't do that with public projects. So what is there to secure your payment? And that is the bond, okay? So who needs to send a notice to owner? And it's very interesting because that document is called a notice to owner / notice to contractor. It's actually a combined form. And that's what notice to own, that's what SunRay does for all of our customers. We make sure that your form is both for private projects and for public projects. Now, who needs to send them for public projects? If you do not have a direct contract, again, verbal or written, with the general contractor who's carrying the bond, then you need to send a notice to owner. Now, best business practices is to always send a notice to owner, even if you have a direct contract with the general contractor on bonded projects. When must it be sent, and when must these notices be received? As I stated before, you have 40 days from the first day you're on the property to send a notice to owner. A notice to owner must be received by the 45th day from first furnishing. Best business practices, once again, you do not want to wait until the final hour to send your notices. As soon as you have the contract in place, verbal or written, you're going to send these notices at the beginning of the project. Yes, a lot of companies use them as collection tools. They're not paid after 35 days. Let me send them. Let's see if this expedites payment. It does not help you in some ways because you could forget to send your notices. I can't tell you how many scenarios I can give you with people who forget to send their notices. So make sure you send your notices at the beginning of the project, and in your system, if you are a SunRay customer, take that work order number and implement that and say, okay, we noticed this. This is our work order number for that project. So what is the first work, and how can I send it? How early can I send it? You could send your notices to owners as early as you wish. You just can't send your notices to owners late. And your first day of work is when you're improving the project. So when you furnish the material to the project, or when you are working, putting up the drywall, that is your first day on the job. And this, I think, is one of the pro tips here is determining a monetary threshold. A lot of people go, you know, Ariella, how do I know how much when I should send like this notice? You know, it's only a $400 job. Well, how many times have we been on projects where the project starts off at, say, $500, and before you know it, it's a $7,000 project with change orders? So really, best business practices is if it's $2,500 or more, you really want to make sure you're sending and securing your lien rights and sending your notices to owners. So that is that with notices to owners in hopefully less than 8 minutes. And back to you, Alex. And if anyone has any questions, we will go over your questions towards the end of this webinar.
Perfect. Thank you, Ariella. So let's talk about claims of lien. What is a claim? What is a claim of lien? So step one is the notice that Ariella said. The claim of lien is the document that is recorded in the public record. It sets forth who you are, who the owner is, who hired you, when you did first work, when you did last work. And it is the document that clouds the title and becomes the encumbrance that you will ultimately, if you have to, use as the basis to foreclose and take ownership or sell the property. It needs to be signed and notarized and recorded in the county where the project is located. So on a private project, who needs to record one? So if you have a contract with the owner, you will record your claim of lien. You don't need to send a notice to owner, as Ariella said, because you have a direct contract with the owner. But everybody else, subcontractors, subcontractors, suppliers to subcontractors, they need to record a notice to owner, a claim of lien in order to secure their right to be paid on the project. As Ariella mentioned, on public projects, there are no lien rights. That is a bond claim. We're going to talk about that next. So sometimes I see folks record claims of lien on public projects. It's not that the clerk is going to reject your lien. The clerk who receives these liens does not look at them, doesn't check dates, doesn't check owners and amounts. They just want to make sure that it's signed and notarized, and they will accept it. So just because the clerk accepts the claim of lien for whatever you put on it doesn't mean that it's valid or enforceable. So if you try to lien a public project, the clerk will accept it, but it is a meaningless document. It will have no effect legally. So when do you need to record your claim of lien? You need to record the claim of lien no later than 90 days from your last work on the project. 90 days is counted starting the day after your last day of work. So if today I show up and I finish all my work, day one is tomorrow. So I count all days, weekends and holidays, all the way through from day 1 to day 90. If day 90 falls on a weekend or legal holiday where the clerk is closed, it rolls to the next day. So if my 90th day was Saturday, it rolls to Sunday, and if Monday was a holiday, it would roll to Tuesday. So it's possible you could have 93 days to record your claim of lien. Let's talk about what isn't last work, because this is always a question that we get. Punch list work, warranty work, and passing inspections. Those items do not count as last work by themselves. Now, you may be doing punch list at the same time that you're doing real work, so that may actually be your last day of work. But if you finished your work today, and a week from now you go back and you are the painter and you touch up certain areas of the building, then your last work is today. It's not a week from today when you went and did the punch list. If you are the plumber and you finish all your work today, and a week from now the inspector comes and you pass your final inspection, your last work isn't the day of the inspection passing, it's the day you did the work. Base contract work and approved change order work does constitute last work for your lien rights. So we had a client once who installed doors, and they missed their 90-day window to record a lien, and he was very frustrated. So he called me and he said, "Can you believe it, Alex? They called me and they want me to install another door, which I have, which they haven't approved. It's $1,000, and they want me to install it, and they'll sign a change order." I said, "You should absolutely do it. Put the door in your truck and go and install it, get the signed change order, because that will revitalize your lien rights, because now you've done an approved change order, and now your 90 days has been reset. So therefore, you have the right to go back and lien the job," which is what he did. So he installed a $1,000 door, and he was able to put a lien on the property for about $100,000, and he was eventually paid because of that lien. Also remember that just because you expect to go back, if you actually never go back to do work, your 90 days may expire. So for example, if you do work and maybe the job gets shut down, or you are demobilized from the job and you think, well, we're going to go back in 2 months, I don't need to lien it now. If something goes wrong and you actually never go back, then you will lose your lien rights, because the court is not going to care that you don't have the ability to go back. If you didn't go back, you didn't reset your 90 days. We saw that a lot with the coronavirus. Jobs stopped, and then the 90 days expired, and some of those jobs didn't start again. And clients called us and said, well, can't I get an exception because of the coronavirus? And the answer is no. If the job didn't restart, you needed to have recorded your lien within 90 days of your last work. And if the last work you did was at the shutdown because of the coronavirus, well, that's the date that matters. Let's go back to that pro tip. Don't wait to the last few days to record your lien. Just like Ariella said, don't wait to the last minute to send your notice. Don't wait to the last few days to record your claim of lien. It takes time to prepare the lien and to record it. Typically, we're seeing recording dates in more populous counties, Dade County, for example. Sometimes that wait time to record electronically, because they're still not letting you in person, can be 5 days. So everything's ready, you submit it to the clerk to record electronically, and it could take 5 days before the clerk accepts it. And that by itself is not a reason to say, well, I did everything I could, my lien should still be good. There's no case to support that. So you need to make sure that you start, in my opinion, at about day 60. So at about day 60 from your last work on the job, you need to make sure that you are starting the process to record a lien, so that you're not waiting till day 85, 86, 87. Let's talk about payment bond claims. And these are the types of claims that you can assert when you work on a public project. So what is a notice of non-payment? A notice of non-payment is, let's call it the cousin to the claim of lien. When you're owed money on a public job or a private bonded job and that contractor hasn't paid you, or if you're a sub or supplier, you haven't been paid, you need to serve a notice of non-payment. It is still a notarized document. It has slightly less information than a claim of lien, and it needs to be prepared and notarized, not recorded, just sent to the interested parties on the project. So that would be the surety and the contractor. So on private projects, who needs to send it? Well, not every private project is bonded, but if it is, then you need to send this notice of non-payment if you do not have a contract with the bonded contractor. So for example, if the contractor has a bond on this private job and I am the plumber with a direct contract with the contractor, I don't need to send my first notice, which is that notice to contractor Ariella mentioned, but I still need to send it on this private job. So within 90 days of last work, I need to send this notice of non-payment. The same is true for public projects. The key is, and I would suggest to you, just like it's best practice to serve your notice to owner, whether you need to or not, you should be recording your lien and serving your notice of non-payment no matter what within the 90 days of your last work on the job. So as I said, it needs to be received by the contractor and the bond company, the surety, no later than 90 days. The 90 days is counted the same as the claim of lien. So if my last day is today, tomorrow is day one, I count every day in between, weekends and holidays. When I get to the 90th day, if the 90th day is a weekend or legal holiday, it rolls to the next business day. It's not recorded, so it's just sent. Certified mail is fine. We typically send it via overnight mail when we're within the last 7 days of the deadline to make sure that something doesn't go wrong with the certified mail. So you can send it via FedEx, priority mail, or certified mail. The test for last work is the same as the claim of lien. So punch list work, warranty work, getting an inspection pass, that doesn't count as last work. It has to be substantive work, base contractor change, approved change order work. That is going to be your last day of work under the lien and bond statute. So here's a little tip. I don't think you should use it all the time, but it's good to know in case maybe there was a slip up that you still have rights. If you are in privity with the bonded public contractor, you don't need to serve a notice of non-payment. So for example, if I'm the plumber on a school board project and my contract is with the bonded contractor, I do not need to send a notice of non-payment in order to have rights on that bond. I strongly encourage you to still do it. You should just have a practice in your office that at any time you're owed money, at day 60, you start the process of either recording a lien or serving a notice of non-payment. But in the rare situation where it fell through the cracks, know that this is one of the many exceptions that exist in the lien law. Also know that not every public project is bonded. There are certain thresholds that have to exist. So just because you're doing work on a public project, don't assume that the job is bonded. For example, the law in Florida is that any job between the public entity and the contractor, if it's less than $200,000, it does not need to be bonded. If it's between 200 and 400, it's at the discretion of the municipality whether or not they want it bonded or not. And if it's over 400,000, then it has to be bonded. So is it possible that you could be on a small public job thinking that it's bonded and in fact there is no bond? Absolutely. So be very careful and check that out before you start your work.
And Alex, I think another note to that, in those situations, if you know that going into this project, that the project is not bonded, what you could do, and it doesn't always work, but you can have a joint check agreement. So that's a way to assist you in some type of, I don't want to say guarantee of payment, but that's something that can help you. So when you're working on the public projects, it's an important question. And it's not a question that you have to worry about asking the general contractor. It's a very normal part of business. Were you required to carry a bond? And if so, may I have a copy of it for our records?
Absolutely. If you're looking to the bond as your primary tool to mitigate the credit risk of this job, well, what if that bond doesn't exist? What else can you do to mitigate that credit risk? And a joint check agreement is a great way to do that. Let's go ahead and put it all together. So from beginning to end, I can give you all the time frames in one slide so you have them all. So within 45 days of your first work, no later than 45 days from your first work, and as we said, it should be sooner, you need to serve that notice to owner or notice to contractor. Within 90 days of your last work on the job, you need to record a lien or serve your notice of non-payment. Again, 90 days being the absolute last day for it to either be recorded for the lien or received by the contractor and surety for the notice of non-payment. Within 15 days of recording the lien, a copy of it needs to be served on all interested parties. When you use SunRay, they take care of all of these mailings for you. So they get done automatically, but this is another obligation that if you do it yourself, not only do you have to record the lien, you need to send a copy within 15 days to everyone on the project. That's listed in the notice of commencement. If you have a direct contract with the owner, there's another document you need to prepare and notarize and serve on the owner at least 5 days before you file your lawsuit to foreclose on the lien. And that's called a contractor's final affidavit. Again, this is only if you have a direct contract with the owner and you have a lien on the project. And then finally, you need to file a lawsuit to foreclose on your lien within 1 year from the recording date of the claim of lien. There's a little asterisk there. We'll get to that in a minute. And if you have a claim on a payment bond, you need to file your lawsuit against the surety no later than 1 year from your last date of work. So notice that a lien foreclosure case has a slightly different deadline 1 year from the recording date of the claim of lien versus a bond claim, which is 1 year from your last date of work. And those little asterisks means that these dates can be shortened. So there are ways for the owner, the contractor, the surety to shorten the time that you have to sue. Sometimes it can reduce it down to 60 days. Sometimes they can reduce it down to 20 days. You will get notice of those documents if they are in effect, but just know that it's not always 1 year. It can be shortened sometimes. So with that, Ariella, do we have any questions?
Yes, we do. We have about 5 questions so far.
All right, let's go.
Let's do it. Does taking measurements count as first day on the job?
Likely not. It needs to constitute a permanent improvement. So furnish improvements under the lien statute means something more permanent than merely taking measurements. However, if you have already have an agreement, a signed agreement ideally, so something in writing, you can serve your notice to owner anytime after you have a signed contract. So if I sign my contract today, I can send my notice to owner today, and I may not show up to the job for 3 months, and that's okay. But if your question is purely taking measurements first work? No, the answer is it is not.
Okay. Second one, to confirm, if there are multiple segments of a job, such as initial lot clearing and sod, once the house is completed, there's only one NTO in the claim of lien.
I'm not sure I understand the question.
I think I understand. Yeah.
Okay, go ahead.
Basically, I think if it is one contract that you have with the sod and the land clearing, then it's one notice to owner. So you're trying to determine how many notices do you send for this project. So if it's the sod and the land clearing in one contract, it's one notice to owner?
Yeah, so the rule is every contract between the owner and the party that he or she contracts with directly, each of those contracts require its own notice to owner. So for example, if the owner hires a contractor and there's one agreement, then all the subs only need to send one notice. So if the contractor hires me to clear the land and then hires me in a separate agreement to lay the sod, I technically only need one notice to owner. The problem that folks have is that I don't have the contract with the owner, so I don't know how many contracts the owner and the contractor have with between themselves. Maybe the owner hired the contractor to do the land clearing and then they hired me, and then they signed a separate agreement to lay the sod and then they hired me. In that case, I need two notice to owners. So our advice is, when in doubt, send multiple notices for each contract you have. You may not need them. There's no downside in sending more notices, but there could be a downside in sending too few notices. Next question, Ariella.
This is a great question. They're all great questions, but this is a good one because it comes up a lot. If the project is placed on hold for COVID, can you file a lien and continue to work on the project once the hold is lifted?
Absolutely. So if a job stops for any reason, COVID or otherwise, financing, if a job stops, you need to record your lien no later than 90 days from your last date on the job. If the job starts again, you can keep working. You now have new lien rights for new work that happens. And then as you get paid for the old money that is made up in the claim of lien, you will partially satisfy your claim of lien until the old money is paid. And if the job stops or when you're finally finished and you're owed new money, you can record a new lien. Remember, the deadline, the absolute latest deadline to record your lien is 90 days from your last work. But you can record a lien as you're working if you want. We do that sometimes for clients that want to exert a little pressure, even though they intend to keep working. So they're working every day and they're owed money and they ask us, please record a lien on the property so the owner knows that I'm serious about getting paid.
So in addition to that, unfortunately, there has not been anything that we have in the laws that have increased your time because of COVID, essentially. So it's the same rules that apply pre and post COVID.
Correct. What's the next question, Ariella?
The next question is, hello, what happens if I've received a notice of non-payment? Great question. A subcontractor has not done their work.
So let's assume that you received a notice of non-payment and you're the bonded contractor. So understand that a notice of non-payment may mean different things to different people. For the purpose of this presentation, it is the statutory document that triggers rights under a bond claim. Sometimes people send a notice of non-payment, meaning here is my notice to you that I have not been paid. It's not a legal document as much as it is a warning or a demand. But if you are the bonded contractor and you receive this notice of non-payment, and it is the legal document that triggers rights under your payment bond, if the sub has not done what they need to do, maybe they're late, maybe they haven't finished their work, maybe you've put them on notice for defective work, maybe you've had to supplement their forces because of issues with them on the job, you have all of those defenses available to you, as does your surety, in order to either offset or recoup from them claims for the defective work or the delays. So just because they file a notice or serve a notice of non-payment doesn't mean that you don't have your defenses. Ideally, you will buttress those defenses with a good written agreement so that you can point to that document as well and say, well, you're in breach of the contract because you failed to meet the schedule. You gave us substandard work. You didn't have the proper men on the job all the time as required by the contract. So the key for those types of things is having proper documentation.
And on top of that, you could also have pictures for evidence to give to your attorney.
Absolutely. What's next, Ariella?
Okay, the next question, and we'll do 2 more questions, and then that's it, and then we'll give everyone our contact information. So if you have, after this event, a webinar, pardon me, questions, you could certainly email us. So the last 2 questions, if I have a project, if a project, pardon me, is public and a notice to owner is sent with the bond information, that would not suffice?
So the notice to owner and notice to contractor are statutory forms. They are very specific on what they need to include. And actually, you know, it's funny, yesterday I was in contact with a client who was using a service other than SunRay for their notices, and I realized that their notice to owner form was wrong. It was not in compliance with the statute, which could potentially invalidate the claim, a subsequent claim. So I urged the client to switch their notice company because clearly they didn't know what they were doing. So if the question is what needs to be in this document, it's very specific pursuant to the statute. What needs to be in the notice and notice to owner, notice to contractor is whatever exists in the statute, and that's the form that needs to be used. So you cannot make your own form to notice the contractor.
Okay. The last question today is, how does a sub know whether to file a lien or send a notice of non-payment? So,
Go ahead, Ariel.
Sure. Two points. In the very beginning, we discussed a public project versus a private project. If the job you're working on is public, under no circumstances can you ever lien it. For private projects, some private projects are so massive that the owner of the property will actually have these projects bonded. So how do you know? You can look at your notice to owner, but really the best business practice is the very beginning of the project. You want to ask your customer, and if your customer is not the general contractor, you could say, I need for our job files a copy of the notice of commencement and a copy of the bond. Now, SunRay will do that research for our customers. But when it comes down to the lien or the notice of non-payment, and again, I want to clarify, a notice of non-payment, just like Alex said, is a claim on bond, claim on the bond. So what do? Private projects, those are the projects you can lien. And if there is a bond, you could of course send your notice of non-payments. For public projects, you can only send a claim on bond. And I want to share with everyone, public projects also include your federal projects. And that's a different notice called the Miller Act notice. So with that, Alex, do you have anything else to share?
Yeah, you know, the easiest way to know is that if you use SunRay, they will send the right notice to the right people, is quite frankly the easiest answer to the question. But if you wanted to know how to whether or not you need to send one or the other, then Ariella's answer is absolutely correct. So let's talk about our next set of webinars and seminars. So on March 10th from 9 to 10:30, so a longer event, we're going to take a deep dive into how to get paid faster using liens, bonds, and different contract terms. Before the pandemic, we would do this as a 2 to 3 hour event in person around the state, but now we do it as a 1.5 hour event on your computer. We'll answer all the questions you have. You can sign up at sunraynotice.com/webinars. That's on March 10th. And as we do every month for 20 minutes, this one's a little longer because we had so many questions. The next one is March 24th from 9 to 9:20, called Pay When Paid Sucks. Do this to get paid anyways. We'll take a deep dive into pay when paid provisions to explain how they work. Ariella, before we go, why don't you tell everyone a little bit about the new SunRay system?
Thanks, Alex. First of all, our website is launched. We have an incredible new deadline calculator on the website, so you can go online and look at your first day on the job, and it will tell you when you need to send your notice to owner, your lien, your notice of non-payments. Our new application, I could send off an email to all the registrants on this call. If you have any questions on our new system, customers already know all about it, but new customers, if you would like to have a 15-minute review of our application, it is absolutely fabulous because it helps you track all your deadlines. But I can send everyone an email on that. So thank you.
If you have any questions, feel free to send Ariella or me an email. Our email is on the screen. Hopefully it's coming. There it is. And we'll go ahead and answer any questions you have either today or later. Feel free to reach out. Ariella, thank you very much.
Thank you very much, and I wish everyone a wonderful and safe day. Bye-bye.